Next case is Hoffman versus Sentry Management. You may proceed.
May it please the Court. Judge Griffin, Judge Schweier, Judge Evander, good morning. We would like to reserve 5 minutes for rebuttal purposes.
Okay.
I'm Charles W. Smith, and to my left is Donald Van Dignan of Van Dignan, PA, and we represent the appellant, Timothy Hoffman. This is an appeal of Judge Jacobus's final orders of dismissal of a negligence count, breach of contract count against Sentry Management, and a vicarious liability count against Sunrise Village. We are not pursuing the appeal in regards to the dismissal of the...
You could speak up just a little bit.
Sorry.
Okay, thank you.
We're not pursuing the appeal of the negligence count as it pertains to Sunrise Village. And before I get into the argument, were there any questions initially? Mr. Hoffman was injured in the course and scope of his employment with Sentry Management on January 16th of 2003. It has been ruled by a judge of compensation claims that this occurred in the course and scope of his employment. Additionally, since C&D has now been defaulted, all of the allegations in count 1 and 2 of the third amendment complaint have been admitted. At the time of the accident, Mr. Hoffman was working as a leased employee for C&D Dockworks, being leased by Omni Staff Leasing Services, Inc., which is a staff leasing company. Mr. Hoffman did not realize he was working for a leasing company at the time. We believed he was working directly for C&D. C&D believed that it actually was carrying workers' compensation coverage through Omni Staffing, but unbeknownst to C&D, Omni Staffing, who is now in bankruptcy and insolvent, did not procure any workers' compensation coverage on their behalf. In regards to that relationship between C&D and Omni Staffing, we have recently done a notice of supplemental authority in regards to the Williams v. Davis case, the Supreme Court holding 32 Florida Law Weekly, Supreme Court 745, which is still an unpublished opinion. But that case basically quashed the actual ruling in regards to the agrarian rule, but otherwise affirmed the other rulings of this court in the other two Davis cases. And specifically, the court needs to be aware of changes in society that use by contractors of the staff leasing companies are creating.
That was a premises liability action where, I thought I heard you say the Davis case, right? That just came out.
Yes. Yes,
that's
sir.
a premises liability action where the issue was whether an intersection was blocked by overgrown foliage. And the court simply held that if the foliage on the property owner spills over onto the right-of-way, then there perhaps may be a cause of that. What does that have to do with this particular case?
Well, specifically in the language where it states that the court must remain alert to changes in our society that may give right to recognition of a duty even when none existed before, for a limited site for my purposes of argument right now. But specifically, the utilization of staff leasing companies by subcontractors is becoming much more prevalent in the state of Florida for provision of workers' compensation coverage. Contractors are then confirming coverage when subcontractors come onto a job site, and most employers using these staff leasing companies have essentially become one step removed from the insurance verification process. Such was the case here. In the case at hand, C&D Dockworks, contrary to the arguments of the appellees in their briefs, we have taken the position, and it was alleged in the third amendment complaint, that C&D
Why
Dockworks...
do you think they would do that?
I'm sorry?
Why do you think that a contractor would look into whether a subcontractor has coverage? Why do you think they would do that?
Well, a contractor would, because a contractor would be liable for any workers' compensation claims if they did not.
Well, you said that we're talking about a subcontractor here. Is that right?
C&D Dockworks was...
Or are we talking about a subcontractor, an independent contractor? What are we talking about here?
C&D Dockworks was essentially a leasing employer. They were the contractor hired directly by SENTRY Management, contracted directly with SENTRY Management.
Why would SENTRY Management want to make sure that there was coverage?
That kind of begs the question.
It wasn't really to protect the workers working for the other entity. It was to protect themselves from lawsuits, right?
Technically, no.
How does that create a duty flowing from them to the worker? They're just trying to protect their own interests. They don't particularly care whether the worker's going to be covered. They just want to protect themselves.
Well,
so how does that create a duty?
The language in the contract itself is moot as to the purpose for who it's protecting. Sunrise Village is statutorily immune, cannot be sued for workers' compensation benefits, much as SENTRY Management cannot be sued for workers' compensation benefits. The contract itself is construed in...
Where does the contract says they're immune from suit?
No, that would be based on case
Where
law.
does the immunity come from?
The immunity comes from the Woods case and the similar cases cited in my briefs in regards to condominium associations, cannot be sued for workers' compensation benefits.
But the workers' compensation would alleviate them from any other type of lawsuit, wouldn't it?
If there was
coverage?
I'm sorry?
My primary question to you is they're not looking out for the worker that's employed by the other entity. They're looking out for their own interest to make sure that they're not going to get stuck with a lawsuit or with having to pay coverage on their own. Isn't that right?
I don't believe so, Your Honor.
You don't think so?
No.
So what they're doing it? So they are looking out for the interests of the worker employed by another entity that's doing work on their behalf. Is that what you're saying?
Essentially, SENTRY Management is acting like a general contractor in this situation. They've assumed the duty of acting as a general contractor.
Is this like a gratuitous undertaking that they undertake to help the worker out? You're saying that they're immune from suit, so they don't have anything to worry about. So is this a gratuitous undertaking that they undertake to do to create the duty?
Gratuitous as it pertains to Mr. Hoffman, but not as it pertains to their contract with Sunrise Village. They're getting paid to do this. It's part of their contract. They're doing it. They advertise that they knew of the dangers of not having valid workers' compensation coverage in effect. They're the largest condominium management association in the state of Florida. Sixth largest in the country. As far as the term in the contract itself, it's moot as to its purpose, but it says at the very end of the contract, page 660 in the record, volume 4, that it's to be interpreted according to Florida law, and under Florida law, neither SENTRY Management nor Sunrise Village can be liable for workers' compensation benefits, which begs the question, what is its purpose? Although they cite to the advertising as being there to protect Sunrise Village, that's not part of the contract itself, and I don't believe it's proper for a motion to dismiss analysis under the standard review. But the duty that they undertook was a statutory duty. They essentially stepped into the shoes as a general contractor for this job site. They assumed the duty of confirming workers' compensation coverage in a contract with Sunrise Village, which Mr. Hoffman was not a party to. However, they also contracted directly with C&D Dockworks. As is set out in the allegations in the complaint, all of the negotiations, everything else was done through C&D Dockwork, and it was C&D Dockwork who was advised by SENTRY Management, we're going to go ahead and check workers' comp coverage for you, and you're not going to get paid until we do it. And C&D Dockworks, very small dock company, who can't even afford an attorney to defend themselves, relied upon those statements by SENTRY management that they had workers' compensation in effect. And it was alleged in the complaint, based on the depositions taken below, that C&D Dockworks would have promptly obtained workers' compensation coverage had they been advised that they did not have coverage through Omni.
So you're saying there's a contract that establishes the duty? It's a contract that establishes the duty here?
There's the two contracts.
The two contracts. But it's a contractual duty, is that right?
First and foremost, yes.
Okay.
However, the contractual duty that was assumed is a statutory duty, because they stepped into the shoes as a general contractor. And a general contractor has the statutory duty to confirm coverage for subcontractors. Although they were not a contractor in this case and cannot be held liable for workers' compensation benefits, when they assumed that duty, which is of great public importance to avoid individuals such as Mr. Hoffman becoming burdens on society, and having workers' compensation benefits in effect, they assumed a statutory duty. And public policy would dictate that the liability based upon the assumption of the duty as well as the detrimental reliance be extended to the circumstances of this case. The E.C. Goldman case cited to by the appellees, it was a case involving an expert who was retained by a county to check out a roof. The contractor did the work on the roof, then sued the expert, alleging faulty evaluation of the project. And as opposed to this case, in that case where privity was not extended, public policy was actually against extending privity, extending liability to that expert, because you want experts to be independent and to be able to render opinions freely. In the case at hand, public policy actually favors the extension of privity and the extension of liability to SENTRY management under the facts of this case. In regards to negligence,
I have in my notes that the exhibits attached to the third amended complaint show that the purpose of the contractual provisions, I think that you were referring to, was to protect the association from a potential lawsuit and to minimize the association and SENTRY's liability in the case of injury or property damage, not to protect C&D's employees from injury. So if I read the complaint, the contract, and the attachments, I'll come to a different conclusion than that.
Well, if there's different conclusions, then obviously it's not ripe for a motion to dismiss, but I believe what you're citing to is actually the advertisement as opposed to the contract itself. And correct me if I'm wrong, but I believe
okay, so that's the exhibits are referred to the advertising, and not the provisions of the contracts.
Well, the exhibits actually have both. Pretty much everything is attached. Okay. In regards to the duty and foreseeability and zone of risk, the restatement of torts, McCain stated that the duty can arise either from legislative enactments, administrative regulations, judicial interpretations, or other general facts arising from the case. When looked at in the totality of the facts alleged in the complaint, SENTRY management undertook actions, statutory duties, to confirm workers' compensation coverage for C&D, contracted directly with them, told them they were going to do this, and then instead of doing what they were supposed to do, they accepted a partially legible, faxed certificate of insurance, which was facially invalid. Listed an insurance company that doesn't exist. Kemper is an umbrella. There's 4 companies that do business under it. Kemper is not an insurance company. Listed a New Jersey company. Listed another company not even doing business in the state of Florida. The policy number was illegible. There were a multitude of different problems with this, but as far as foreseeability, the contract and the advertising itself establishes the foreseeability that someone such as Mr. Hoffman would be injured on the job and not have workers' compensation benefits if they didn't fulfill their promise, if they didn't do their job. And they didn't do their job. And as a result...
Do you have a case directly on point with facts very similar where the courts have held that there was a duty that was established under very similar facts?
We've cited to a multitude of different cases in the briefs. As far as something right on point, I think the Sheridan case probably comes about as close as...
The Sheridan?
Yes. However, and this would be another...
I think that's your best case, Sheridan?
It's one of the better cases. I can see that I'm running out of time here. The Gwen case and the Tucker case, although they don't establish facts exactly under these circumstances, are also very close in regards to equitable estoppel, detrimental reliance, and third-party beneficiary arguments. And I can see I'm down to 5 minutes.
Okay.
Good morning. May it please the Court. My name is Jamie Bellotti-Moses from Fisher Rushmer in Orlando. Ms. Wheeler and I are going to divide the appellee's time, 13 minutes and 7 minutes. I will watch the clock to make sure that I leave her her time. Okay. I am here today on behalf of Century Management. We are the management company for this association. We are seeking an affirmance of the dismissal with prejudice because we believe that it was appropriate for the trial court to dismiss with prejudice the third amended complaint because it failed to state a claim and could not be amended such that a cause of action could ever be stated against us. Several issues were raised during appellant's presentation. I know that Judge Sawaya asked about whether all of the exhibits together, along with the allegations of the complaint, would suggest anything other than the intentions of the parties were to benefit Century and Sunrise in the management agreement. Clearly, the documents demonstrate an intention to protect Sunrise and Century and not a future employee of someone who might be doing work on the property. In fact, what is so obvious about that is, number one, in the agreement itself, at record site volume 4, page 657, Century actually requires Sunrise to execute a waiver if Sunrise makes a decision not to hire someone without insurance. Century wants to be absolved of responsibility for the risk that might arise from that. In the advertising materials at the record at volume 4, 675, it specifically says managers are trained to require proof of insurance from contractors to protect the association from a potential lawsuit. It is clear that the contractual documents between Sunrise and Century were to protect each other in the event that a worker came onto the property, got injured, and his employer did not have insurance. There is nothing in the contractual documents which would entitle Mr. Hoffman to third-party beneficiary status under the management agreement. And to be a third-party beneficiary, you have to establish a contract, a clear intent by both parties to benefit the party that is now suing, a breach, and then damage resulting from that breach. There can never be demonstrated.
That third-party beneficiary would be a contractual cause of action as opposed to a negligence cause of action, wouldn't it?
Yes, sir.
Where you have to establish a duty and the breach of the duty and the standard and all of that.
Yes.
You agree with that?
Yes. And in fact, we've been sued for negligence and breach of contract. I'm sorry, was there a further question?
No,
okay.
I just wanted to make...
And Judge Sawaya, you touched upon the critical issue earlier with respect to the negligence claim, is how could there ever be a duty in this case? Duty is a question of law which was appropriate for the trial court to decide. And the trial court determined that there was no duty on the part of Century to protect Mr. Hoffman. And that's basically what's been alleged here. You're not our employer, you're not a statutory employer, but darn it, you should have made sure that my employer had workers' comp insurance. And there is simply no such duty under Florida law. You have asked opposing counsel if there was a case that was supporting his position, and he cites to the Sheridan case out of the 3rd District. And the reliance upon Sheridan demonstrates the fundamental flaw in appellant's efforts in this case. And that is, and it's the same for the Gwen case and the Tucker case. In all of those cases, the employer retained an insurance agent to get them the coverage they're supposed to provide. Just like me going into State Farm and saying, I need auto coverage, please get it for me. In Sheridan, they didn't do it right, and they got to sue the insurance company. In Gwynn, the employer went in and said, I want insurance coverage, I want my officers covered. What was eventually issued to the employer didn't cover the officer. So when the officer got hurt, they sued the insurance agency for failing to get the appropriate insurance. In Tucker, the employer went to an insurance agent, said, I want the insurance to be effective as of October 13th. Someone got injured that night. They found out later the policy didn't go into effect until 2 to 3 days later. The employer had a right to sue the insurance company because the insurance company did not do its job. There are no allegations in this case, nor could there ever be any allegations in this case that Sentry was asked to retain insurance for C&D or Omni. It's just not an allegation that can be made, and therefore every case relied upon by the appellants does not apply. Simply does not apply. I would also like to bring to the court's attention quickly that the other side has said they could never be liable, they're not an employer, they're not a contractor, and then in the next breath said we were acting as a contractor and therefore we should have made sure that one of the subs had insurance. Again, that is not accurate. That was not our role in this circumstance. All that we did negligently was accept a faxed copy of a proof of insurance. The allegation is that that document was a forgery or somehow a misrepresentation. If we had followed our own internal procedures and gotten the original document, we still could not have been able to tell that it was a forgery or a misrepresentation. But we are now being asked to provide workers' compensation benefits, basically. That's what this case is about. My employer doesn't have them, so you need to pay them, for someone that's not our employee and someone that we did not take on an obligation to procure such benefits. Judge Jacobus properly dismissed this case with prejudice. There is no possible way it could be amended to state a cause of action, and the court has, for its benefit of review, the fourth amended complaint that was subsequently filed after the dismissal. It still doesn't state a cause of action. So if there's any doubt by this court, could it be amended to state something? The fourth amended complaint does not state a cause of action. All that's been added against my clients is we defaulted against C&D, you now need to pay that judgment. If the court doesn't have any further questions, I will turn it over to Ms. Wheeler.
Okay.
Okay, thank you.
Ms. Wheeler?
May it please the court, I'm Elizabeth Wheeler. I'm here representing Sunrise Village Condominium Association, and my co-counsel Robert Mixon is in the audience. I basically reiterate everything that Ms. Moses has said. I would like to touch briefly on something that was raised in the brief and most recently by the Notice of Supplemental Authority with respect to the Davis versus Williams or Williams versus Davis case, however it's currently phrased. That case was strictly a tort case asserting negligence. There's been a negligence count asserted against Sentry for which Sunrise is asserted to be vicariously liable. I think that, number one, I would like to just impress on the court that if there was any duty at all created by this contract, and this is where they say the duty was created, was by the contract between Sentry and Sunrise. If there was a duty created by that contract which Sentry breached, then it seems absurd to me that Sunrise could be held vicariously liable for a breach of its own contract. But beyond that, the Davis versus Williams case, I think, kind of expanded on the foreseeable zone of risk doctrine that was first set out by the Supreme Court in the McCain case. And I think if you look at all of those cases, including Davis, that foreseeable zone of risk is one of physical harm to persons or property. In this case, they've made it stated several times, stated in the trial court, in their briefs. In this case, they are not claiming that anything that Sentry did resulted in the accident or the physical harm that was sustained by Mr. Hoffman. They're just claiming that it resulted in there being no workers' comp available. That is not even within the scope of the McCain Doctrine. And so for that reason, I think that all of those cases just don't apply in this case. They also have relied on the voluntary undertaking doctrine, a couple of cases that they cited in their brief, as well as the restatement second. I think it's section 324A. Again, that specifically applies to a voluntary undertaking which increases the foreseeability of physical harm to a third person. And they're not claiming that any physical harm resulted to Mr. Hoffman as a result of this failure or alleged failure to confirm workers' comp coverage. So unless the court has any questions with those comments, we'll stand on our brief and request you to affirm.
Okay.
Thank you.
5 minutes and 15 seconds.
Thank you. Again, there was a second contractual relationship entered into between Sentry Management and C&D Dock Works, which was a direct contractual relationship and upon which C&D relied. C&D was told that their insurance was being checked on for them and was going to be confirmed before they were paid. They were paid, then Mr. Hoffman was hurt. Had they done their job and confirmed it, there would have been coverage for this date of accident.
They bring up a causation issue. How does that, if we're talking about negligence, you have to establish causation. You have to establish that, number one, I don't even think you can establish a duty of care, but let's assume that you did. You establish a duty of care, you have to establish that the duty was breached and that was a proximate cause of the injury. How can you do that?
Well, that's exactly the Gwynn and the Tucker cases.
What?
That's exactly the Gwynn and the Tucker cases, when there was somebody who failed to, in that case, procure
You're talking about
insurance.
insurance coverage.
Yeah.
How is that the proximate cause of the injury?
Of the accident, it was not. Of the damages and the harm, it was. They did not cause the accident. However, had they fulfilled...
So you don't get to damages unless you establish proximate cause in a negligence cause of action. The cases are legion on that point. Isn't that correct? You only get the damages once you pass the first three hurdles: duty, breach, and causation. Then, and only then, do you go to damages. So how do you get your damages if you can't establish causation?
Well, the Gwynn case and the Tucker case both establish causation based upon an insurance agent's failure to meet their promise. And the damages in those cases...
But that has to do with an insurance agent failing to get insurance coverage for the person that employed the insurance agency to do its job in the first place.
Well,
that doesn't have anything to do with the contractual obligation on the part of these entities to see if there was workers' compensation coverage for an employee that's employed by somebody else.
Well, if you look more specifically at the contractual relationship between Sentry Management and C&D, it's clearly foreseeable based on C&D's reliance upon Sentry's actions that Mr. Hoffman could be injured on the job without the benefit of workers' compensation coverage.
Okay.
When a defendant's conduct creates a foreseeable zone of risk, the law generally will require a duty placed upon the defendant either to lessen the risk, to see that sufficient precautions are taken, or to protect the others from the harm that the risk poses. For the minimal threshold foreseeability to open the courthouse doors in regards to duty, the question is whether the defendant's conduct foreseeably created the risk. And again, the risk would be that Mr. Hoffman would have no workers' compensation benefits for him, that he'd be left with $2 million in hospital bills, without attendant care, without someone to take care of him, without someone to roll him over in bed so that he doesn't get constant bed sores.
He certainly has a cause of action against the tortfeasor, doesn't he? The person whose negligence actually caused the injury. I mean, if you don't have workers' comp coverage, well, then you're free to go ahead and sue the tortfeasor. So he has that cause of action.
I'm sorry, Your Honor. But for the actions of Sentry Management in failing to meet their promise, C&D would have had workers' compensation coverage.
Well, you keep talking about this promise.
Yes.
I've looked at the allegations in your complaint. I think it's around paragraphs 71, 72, around in there. And you don't allege a promise. You don't allege that Sentry promised C&D that for C&D's benefit it would verify C&D's workers' coverage.
What they told them was,
What they told them was, we ain't paying you till we're sure you got comp coverage.
that's correct.
That's not a contractual undertaking.
When it's detrimentally relied on, I believe that it is, citing to the case law that we have dealing with detrimental reliance. I'm sorry. There was a direct relationship between C&D and Sentry Management, wherein C&D was told, you're not going to get paid until we confirm coverage. C&D was using a staff leasing company for their workers' compensation coverage and was one step removed from the actual verification process. Sentry then didn't just accept the facts. They accepted the facts directly from the leasing company who's supposed to be paying for the insurance.
Sentry calls C&D and says, prove you've got comp coverage. C&D says, hey, we've got this leasing company. And so Sentry says, we ain't paying you till we verify that you got comp coverage. And they accept some kind of invalid certificate. And so C&D has a right to rely on Sentry's failure to verify coverage.
I see that my time's expired, but if I could respond quickly, Your Honor.
Hopefully your answer is yes, an answer which may be debatable.
One thing to keep in mind is that the officer of C&D Dockworks was also an officer of Sunrise Village. It's inferred that all the knowledge that Sunrise Village had, C&D had, as far as the terms of the contract and what they were supposed to do and what they weren't supposed to do.
I will relieve you. Your time is up. Okay.